trial of someone's case by magistrate. So according to 274, where in a summons case the accused person appears. Summons case means very summarily you can dispose of the case, very minor offences. So in that case, when the summon is sent to the accused person or is brought before the magistrate, the particulars of the offence of which he is accused shall be stated to him, and he shall be asked whether he pleads guilty or not, or has a defence to make, but it is not necessary for him to frame formal charge. Now section 275. So if the accused person pleads guilty, then the magistrate shall record the plea as nearly as possible in words used by the accused, and may in his discretion convict him thereon. So if the person will plead guilty, then he will be convicted thereon. If he does not plead guilty, means he wants to place his defense. So according to section 276, where a summons case has been issued under section 229 and the accused person desires to plead guilty to the charge without appearing before to the magistrate, he shall transmit to the magistrate by post or by messenger or a letter containing his plea, and that will also amount of fine specified in the summon. So if he is not if he is out of station, if he cannot appear physically, in that case he can even report his attendance through post and all. Okay. Now according to section 227, if the magistrate does not convict the accused under section 275 or 276, the magistrate shall proceed to hear the prosecution and take all such evidences as it may be produced in support of the prosecution, and also to hear the accused and take all such evidences as he produces in his defense. The magistrate may, if he thinks fit, on those application of prosecution or the accused, issue summon to any of the witnesses directing him to attend or produce any of the document or thing. Same thing, whatever we have studied in other two trial processes, the process is almost similar. The magistrate may, before summoning any witness on such application, requires a reasonable expenses of the witnesses that is incurred in attending for the purpose of trial to be deposited to the court. So whatever the cost of bringing that document or witness is required, that must be deposited. Okay. Now according to section 278, if the magistrate, upon taking evidence referred to in section 227 and such further evidence, if any, as he thinks of his own motion, cause to be produced, finds that the accused is not guilty, he shall record an order of acquittal. Okay. So if he finds that there is no ground to proceed, he will acquit the person. So where the magistrate does not proceed in accordance with the provisions of section 364 or 401, he shall, if he finds that the accused is guilty, pass sentence according to the law. So a magistrate may, upon section 275 or 278, convict the accused of an offence that is triable under this chapter, which from the facts admitted or proved he appears to have been committed, whatever may be the nature of the complaint or summon, if the magistrate is satisfied that the accused would not be prejudiced thereby. Now 279. If the summon has been issued on complaint and on the day appointed for the appearance of the accused, or on any subsequent date thereto to which hearing is adjourned, the complainant does not appear. So if the complainant fails to appear, in that case the magistrate shall, notwithstanding anything herein contained, acquit the accused unless for some reasons to be recorded in writing. For example, if the case has been instituted on a complaint case. Complaint case means you are directly filing to the court. In this case the procedure is followed. Now if the complainant at the time before the final order is passed in any of the case under this chapter satisfies the magistrate that there are sufficient ground for permitting him to withdraw the complaint against the accused person, then, or if there is more than one accused against all or any of them, then the magistrate may permit him to withdraw the same and shall thereupon acquit the accused against whom the complaint has been withdrawn. Okay. For example, if you are directly filing to the court and later you found that no, that person was not involved and you want to withdraw the name of the person, that is also allowed under section 280. Okay. Yeah. Now, according to section 281, in any summons case instituted otherwise than the complaint. Otherwise than the complaint means on FIR. Okay. A magistrate of first class or with previous sanction of the CJM, that is Chief Judicial Magistrate, or any other judicial magistrate for the reasons to be recorded by him, stop the proceedings made after the evidence of the principal witness have been recorded and pronounce a judgment of acquittal, or as the case may be, release the accused, and such release shall have the effect of discharge. Now, according to section 282, so where in the course of a trial of a summon case relating to an offence that is punishable with imprisonment that exceeds 6 months, if it appears to the magistrate that in the interest of justice the offence should be tried in accordance with the procedures of a trial of warrant case, then such magistrate may proceed to rehear the matter in the same way as provided under this Sahita for the trial of warrant case, and may recall any witnesses who may have already been examined. So during the course of trial, if the magistrate thinks that no, this is not a summon trial case, this is a warrant trial case, so in that case what the magistrate will do, it will again try the matter according to warrant case. We have already studied trial of warrant cases. Okay. Any doubt?